A Supreme Court judge who is always known to add humor in very tense courtroom situations. Justice Hrishikesh Roy has been known to add anecdotes, quotations from book, and also snippets from his early legal career while concluding very heated constitution bench hearings. A judge who has passed very strict orders in his court while maintaining a very calm, composed entire being. Thank you so much, Justice Roy, for being with us today at this Bar and Benches interview series.
Thank you for having me. Bar and Bench has a very major presence, and I'm delighted to be in this conversation.
Thank you so much, sir. Sir, your career trajectory has spanned from the easternmost part of the country to Kerala, which is there in the south, and now it concludes in Delhi. How do you look at this entire journey that has actually spanned across India?
A bit of a correction there in your description. It started from Delhi,
of course,
and it is ending in Delhi because I was educated,
Yes.
and then I commenced my practice in Delhi in 1982.
Of course.
And for a couple of years I was here, and there was a family tragedy. My father passed away, so that needed me to go back to Guwahati. That's my hometown. Be with my mom, be with my siblings. So of course, then if you call which is my parent high court, of course it would be the Guwahati High Court. But I started my journey in Delhi, Supreme Court and the Delhi High Court in 1982.
Okay. So how do you see this entire journey that has happened over these years?
The journey, now it has been about 19 years.
Right.
And I really feel fulfilled as a person for the career in bar and also career in the bench.
Right.
To take the two words from your organization. I started, of course, as a lawyer in Supreme Court. My first day's, opening opportunity to speak anything before the Supreme Court was before Chief Justice, the then Chief Justice's court, not the Dhananjay Chandrachud, but Yashwantrao Chandrachud, the father.
Of course.
And I had to say that let the matter be passed over. And then when I was pushing ahead, because there was a crowd of lawyers before item 17, when I was pushing past, and I said it, then I suddenly realized to my horror that no sound is coming out of my mouth. And the judges were not reacting to my request for a passover. And then when I said it next time, it came out very in a belligerent way. So the judge did pass over the matter, and then at the same time, they gave me a little stern look that why this man is being so belligerent in requesting for a passover. So that's how it started. But then your initial thing, it's the same for all young lawyers starting out in life. So we started here, and then eventually I sort of developed my practice in Guwahati. Those days, once in a while, I used to come to Delhi also, whenever the opportunity for appearing in some matter was there. And then at some point to go to Kerala, and then eventually to the Supreme Court. So I have started in 1982 as a law graduate, fresh law graduate in Delhi. And now I'm demitting office shortly as a judge of the Supreme Court, again in Delhi.
But has life come a full circle, or it's going to take more turns now?
You see, full circle when you say, in the bench, full circle certainly. But for a person who is experienced in law,
Right.
I don't think his journey in law ever ends.
Right.
So in that sense, there is another journey which I foresee. But it may not be a journey which is in any official capacity. So I hope to utilize my time to sort of spread the joy that I have had by being associated with the profession and pursue some of the interests that I have. Now that there is not a 10 to 5 call for me, and also the 60-70 briefs that come to a Supreme Court judge's home every evening. So I'm looking forward to life after demitting office as a judge of the Supreme Court.
In whose chamber did you start practicing law in way back in Guwahati High Court? And you're a first generation lawyer.
First generation lawyer, yes.
So how difficult was it, and how did you make it to the chamber? Because I think Justice Kohli told me that the only important thing in a lawyer's life is to make it to the good
right chamber. Right chamber, yes.
So
you see, I commenced my career in Delhi in 1982, but I lost my father, so I had to relocate to Guwahati. Now, having been in Delhi, I saw the best of lawyers: Ashok Sen, Siddharth Shankar Ray, K. Parasaran, Nani Palkiwala, all the stalwarts. I saw them. So when I had to relocate to Guwahati, I decided for myself that I must work in the chamber of the best lawyer.
Right.
And I lost my father. I had no way of knowing who is the best lawyer. So I went to the court. Anyway, one could identify that there are these 4-5 lawyers who are very good. So starting at 10:30, I will follow a particular lawyer from court to court.
Okay.
And then I assessed how he is. Then I follow lawyer B from court to court. So after a few days, I sort of, let us say, raked all the lawyers.
Okay.
And then I said that this is the lawyer I want to be with. And his name was J.P. Bhattacharjee.
Okay.
The doyen in the Guwahati bar, and a lawyer of such immense knowledge and court craft and everything, absolutely top notch. And my belief was that he could be a match for any of the outstanding lawyers in the country at any given time.
Right.
And he was master of all branches of law.
Okay.
Civil, criminal, income tax. If there is a very big criminal matter, he will be there. If there is a very big tax matter, he will be there. Corporate, anything. And suppose a lawyer has a litigation, personal litigation of tax or of some civil matter or some property dispute. His first preference for a lawyer is Mr. J.P. Bhattacharjee. So J.P. Bhattacharjee's chamber has generated 5 Supreme Court judges.
5?
4 including me, 5.
Right.
If you include somebody, when he was Advocate General, the other person was the additional Advocate General. But 4 actually worked in a chamber.
Who were they, sir?
That is Justice Mukunda Sharma, who was in Delhi High Court and then he came to Supreme Court.
Right.
Justice Amitabh Roy, who was Chief Justice of Rajasthan High Court and Odisha High Court, then came to Supreme Court. And Justice Ranjan Gogoi, who was Chief Justice of Punjab and Haryana High Court, eventually became Chief Justice here. India. And so I am the 4th one from that chamber. In the Supreme Court, there are several in the High Court, and there are multiple senior advocates who are practicing and doing very well out of chamber of J.P. Bhattacharjee. So J.P. Bhattacharjee in Guwahati particularly was the last word. Just to wind up this particular point, in one of his birthday, all of us were there. We were thinking what to give. Then it struck me. I got a plaque made from Delhi, one of those brass plated plaque, written something. The words that I got written there was, because for all litigation, everything will come to him. And that is where the solution will be. And the plaque read, just like in the US President's desk, the buck stops here. That is what J.P. Bhattacharjee is about. And other lawyers describe those from the stable of J.P. Bhattacharjee as lawyers from J.P. Gharana. That is how they used to describe us.
J.P. Gharana.
J.P. Gharana. Because we have a similar kind of writing notes, preparing.
Coming from the same chamber.
Yeah, so they used to. This lawyer was Niloy Datta, very eminent lawyer again. He passed away. So he named our group of people as J.P. Gharana lawyers.
So you and your, a whole bunch of classmates were in the Campus Law Center, Delhi, who were there in the Supreme Court as well and are there in the Supreme Court as well. Did you ever envision you or the others who were pursuing law at that time at CLC Delhi that, you would one day end up in the Supreme Court of India?
For me, not at all. And I'll tell you how I began my journey as a judge, which I'll tell you shortly. One person whom we all thought who will become a judge is my good friend Justice Ravindra Bhatt.
Okay.
He was a very serious student, and very often, while we may be engaged in other leisurely activities, you will find Justice Ravindra Bhatt seated in the library, pouring through books, pouring through notes. So we thought that this man has all the necessary symptoms to become a judge.
Okay.
Uh, Dhananjay Chandrachud, of course, his father was the Chief Justice, so we also thought that he might just opt for it. Sanjay Kaul, who is the other batchmate of mine, we thought that definitely he will become a lawyer, but judge we didn't think, at least in the law college days, because Sanjay Kaul was also interested in theatre like I was. So he had several activities, but so was the case with the former Chief Justice Dhananjay Chandrachud, who was a radio jockey, who sort of did date with you and armed forces request program on the All India Radio. So people had varied activities, but I think consciously, at least I didn't think that I'd ever become judge. Justice Chandrachud, I don't know, because his father was already CGI. But perhaps Justice Sanjay Kaul and I, we don't think we ever thought. But law certainly was a career option, which I had selected even when I was a child. Child meaning when I was a class student of, say, class 5 or 6.
Okay. Okay.
I thought of law as a career even then. Lawyering as a career.
So then how did judgeship happen?
Well, judgeship happened at a time when, this was in 2006 when I got recommended for judgeship. Justice B. Sudarshan Reddy was the Chief Justice of the Guwahati High Court. 2 years earlier, in 2004, I was designated as a senior counsel.
Right.
And so once you get designated as a senior counsel, the profile of the kind of cases that you are dealing, it changes. It becomes more challenging.
Of course.
So legally speaking, it was challenging. Since I had a bit of a background in Delhi, so I earned some bit of a name. So I have had occasion in Guwahati High Court to be the opponent of stalwarts who used to go from Delhi. I can name few like Ashok Sen, Soli Surabji. They used to go for matters to Guwahati.
Right.
And I used to find myself in the opposing end in some of those cases. There was this battle which carried on for a couple of days. Soli Surabji on one side and I was on the other side. The case arguments ended. The court reserved the judgment, and then message came, which I came to know later, not at that point of time, that Chief Justice wanted to offer a cup of tea to Soli Surabji. So he went and met Justice Sudarshan Reddy, and then this again I came to know much later, years later, that Sudarshan Reddy was told by Soli Surabji that my opponent in this case was Hrishikesh Roy. I think you should consider him for judgeship. Then apparently Sudarshan Reddy pulled out a piece of paper. He said, his name is shortlisted here. I am thinking seriously of considering him for recommending to judgeship. So that conversation I came to much later. Soon thereafter, Chief Justice asked me for a cup of tea in his chamber in the court. So after the court work was over, I went. So he broached the topic of inviting me to the bench. So I immediately told him no. And there were several reasons. I may just highlight one or two. The first, of course, was that I was at that stage of profession where I was arguing interesting matters. Earlier, I did a lot of pro bono matters. Some money was also forthcoming. And at that point of time, I was heading the Guwahati Music Society, and we were doing interesting concerts. And you are a media person now, I was the legal correspondent of the Assam Tribune.
Wow.
I was the legal correspondent of the PTI, though my write-ups on the law reports were being published. And so music, I don't know whether you are familiar with the Shillong Chamber Choir.
Of course, sir.
Shillong Chamber Choir, the first show they did out of Meghalaya was in Guwahati.
Okay.
We were the host as Guwahati Music Society. I was the president there. The performing artists now, they were all school children then. So they came with Neil Nongkinri, the pianist and the conductor. So they did the first show out of Meghalaya in the Don Bosco Auditorium in Guwahati, school auditorium in Guwahati. I could not sing. I did not play any instrument, yet I was the president of the music society. So the others who could sing, and they were all on stage in different capacity. So I was comparing the show of the Shillong Chamber Choir in Guwahati. There, for the first time, Shillong Chamber Choir attempted to do an Assamese song, O Mur Apunar Dekh, bringing in a bit of an element of fusion. They do pure classical, only the very solid classical work of Bach, Beethoven, Mozart, like that. So then they got such a fine response for having done that Assamese song in a fusion way. They went back and deliberated, and thereafter there's an evolution of Shillong Chamber Choir into what they have now become, a very phenomenal group of singers. So those were the exciting times I was living in. And to come to the bench, which meant that I would have to avoid all this, was a little discouragement. But then you said that, then why did you? Or there could be a logical answer, then why did you? You see, Chief Justice Sudarshan Reddy, he kept offering me tea every 2-3 days time. And then one day he invited me and my wife Chandana to his residence. Again, offered me a cup of tea. And then again I said no, and I went back. And then thereafter, after maybe some more days, I said yes. And why I said yes is the story that I'm telling you now. Years later, after I became judge, I went and I was visiting Hyderabad for some event. I met Justice Sudarshan Reddy in his residence, who was my former Chief Justice, who came to the Supreme Court and retired from Supreme Court. So I had my tea, etc. We had our chat. Then I was getting up to go. And that moment he said, Hrishikesh, go back to your wife. Tell her that I have freed her of the oath that I have extracted out of her. So I was a little puzzled. So then once he said that, he realized that he should not make me wait till I reached back Guwahati to get the answer. So he narrated it himself. He said, remember you and your wife, you were invited to my residence. At that point of time, I could understand that your wife was inclined to you becoming a judge, although you were resisting it. So then he told me that he chalked out a plan with my wife, swearing her to secrecy, that I will work on Hrishikesh, on his saying yes, and at home you will work on Hrishikesh for him to say yes. So Chief Justice offers me tea, I say no, and then I go back. My wife offers me tea, Chandana, and she also says, it's not a bad thing becoming a judge. So how long can you resist the pressure of Chief Justice and the wife at home? So I said yes. But then having said yes, within a few weeks, I realized that I had done the right thing by saying yes to judgeship.
It was the good call.
Yeah, it's a good call, I must say.
So one of your statements, which in today's parlance is called as going viral, was that when a lawyer requested you that you had passed a similar order in a case as a High Court judge, so you grant me the same relief because the facts are same. But you had retorted saying that I have become wiser since then. Now, this entire thing that you had said, that you had become wiser since then, how do you look back at that observation now, in the sense, how does a judge become wise when they become to the High Court, especially when you are dealing with a matter of similar nature?
That's an interesting question, I must say. You see, you don't become wiser in that wiser sense.
Right.
Meaning thereby the input, we are talking about similar kind of cases. The input that I got or the assistance that I got from the lawyers in Guwahati may not have been adequate for me to reach the right conclusion. So therefore, unknowingly, I mean, this I'm talking now, I may not have given the right verdict in that particular case.
Okay.
But when the facts and the law are presented to you in the manner it should be, then I know that the conclusion in this case can't be the one that I gave in Guwahati.
Right.
So that's why the comment was that I have become wiser. But it is not so much wiser, but the lawyer on the other
Assistance from
side
the
was perhaps the assistance was lacking. And of course, what is wrong in saying that I have become wiser? Because every day you learn something
New.
and your experience of what you have learned on a day earlier or a month earlier or a year earlier, it doesn't remain static. Law is a very moving kind of a subject.
Right.
It is evolving all the time.
Right.
That's why the interpretations change.
Absolutely.
That's why the larger bench set aside the earlier judgment. So therefore, we all become wiser. And why it is only in law? It is also in life.
Absolutely. So you were a part of the bench that allowed the practice of Jallikattu, and the judgment had kind of criticisms, kind of support from different sections of the society. Although the decision was unanimous, could you shed light on how do we balance animal rights with that of cultural rights?
You see, in a case like this, of course, that judgment I did not author. I was part of the bench.
Yeah.
You know that. There are sentimental aspects. Sentiments cannot be judged by pure law. And we have situations of people talk about artificial intelligence and doing judging. You see, the element of empathy, the element of human touch, it can never be brought by artificial intelligence.
Never.
So therefore, in cases where we have situation of, aspirations, festivities, social norms, past practice, if you judge it by standards of pure law, you may not reach a right verdict or a just verdict. So there you will have to balance equally the needs of both sides.
You mean to say human sentiments and that of
Also,
the legal
traditions and how that tradition is so sentimentally close to the people of that area.
right?
The danger of getting injured is not unknown. Yet, people are willing to test their mettle. And certain parts of things are also exaggerated.
But do you think that the value of human sentiments overrides constitutional rights?
Constitutional rights are the supremest. There is no doubt about that. So when I say that judgment was passed, it definitely respected the constitutional values and the norms. Only within those parameters the judgment was delivered. I don't think there is any violation of any constitutional law.
No,
Otherwise, we could not have given a judgment purely on sentiment. In fact, that would have been a wrong approach.
Right. So, is there any, this spans across your career, but is there any Supreme Court case that you, of course, weren't a part of, but you really feel in the hindsight that you would have done justice to the case if you were a part of the bench, or would have decided differently? There must be one case.
You see, there could be very many cases of that kind, but the gender issue in the Sabarimala judgment, I felt that what Justice Indu Malhotra decided, she was the dissenting judge.
Yes.
Having been Chief Justice in Kerala, those days the hearing was going on, I was Chief Justice in Kerala. I could understand the sentiments that are associated with the rituals that are practiced for centuries in that temple.
Right.
So therefore, to go by pure law and disregarding what the faith and the belief of the people, to give weightage to pure law, there Justice Indu Malhotra, she had the dissenting opinion,
Right.
although she was the women judge, the only women
Yeah.
judge in that bench. So I felt that, maybe I would have sided with the view that she espoused,
Okay.
although that was the dissenting view,
So if you were a part of the Sabrimala bench.
if I was a part of that bench. I'm
Right.
just off the cuff, I'm saying
No, of
that,
course,
but,
because I believe that, as a judge, you must be having these thoughts almost every morning that, this judgment has been passed. Is it correct?
yeah, I mean, those thoughts would come, and sometimes the judgments are actually tested before you.
Yes, of course.
That is there, and one has had a pleasant experience of what was that case? That case on, this case is NN Global.
NN Global, yes.
I rendered the dissenting judgment sitting in a 5 judges combination. And lo and behold, I think this is the only example of maybe recent decades, I should say, where a 5 judges bench, the majority verdict was overturned within about 6 or 7 months by a 7 judges bench.
Yes.
And the 7 judges bench upheld the view that I
Dissenting
projected as the dissenting judge in NN Global. I consider that to be one of the, very satisfying moment for
Very
me.
satisfying moment.
That I took a different view, and the different view, sometimes it takes years and decades for the other view to be accepted. But here, within 6-7 months, the larger bench of 7 judges, they accepted the view authored by me as the dissenting judge in NN Global case. That's an arbitration dispute, right?
So you were a part of the collegium that interacted with Allahabad High Court Judge Justice Shekhar Yadav after his controversial comments. We're not getting into the controversy at all. Little was shared with the media, rightly so. But do you think Justice Yadav was censured enough? Is my first question, limb of the question. And second, what do you think is the larger picture behind this? It's just not one-off case. There has been such instances and cases across the country. And with the power of social media, now these instances come to the light, as soon as the words are spoken. What is the way out?
You see, now I can't be commenting on individual cases. Judges of the superior courts, they are protected by so many safeguards so that they can render judgment free of fear or favor.
Of course.
And that is the fundamental thing on how you are trying to protect the judge's functioning as a judge, true to his oath, true to the Constitution. Now, the very same protection by law acts as a deterrent for taking action against somebody who might have seen us going astray. The only way is an impeachment process, which even I know is very ineffective. The other process of in-house inquiry, again, I don't know. Of course, that is what in this particular case, that is the process which is underway. Taking away judicial work could be one of the options, but how does that help? Because somebody might be getting his salary and just sitting at home. I think our present law, it doesn't really have a very effective answer to deal with this kind of situations. There was another incident which had happened relating to another judge who made certain such comments. Of course, there, the concerned judge, he apologized the very next day. But here, in the case that you mentioned, the apology has not been coming, although an assurance was made that an apology will be tendered. But since that has not been seen forthcoming, so the mechanism of an in-house inquiry is the option that the Chief Justice has. I think that has come onto the media, I suppose.
Yeah, but did the judge really justify his statement, or did he express regret?
Perhaps it is known. I mean, anyway, at the end of the thing, he did say Yes, no, he said in private that I'm ready to apologize to all five of you. And he offered to do that right then and there. But it was told to him that apology to in this closed room will not going to do. So you must do it to in a public forum. And the time when he left, he agreed to do that. But then eventually, after some
Change of
years,
heart.
yeah, there was change of mind, change of heart. So it didn't happen.
So the present laws, you say, is not really.
Inadequate to deal with situations.
But I think it's one of the very first times that a judge has actually pointed out that the impeachment process is ineffective. Because
no, we have seen our experiences. I'm speaking from whatever experiences,
of course.
the impeachment process that have started.
Very tough to go through.
I mean, because you are actually protecting the judge in the higher judicial position, so that he is able to render justice without fear and favor.
Right.
That same protective mechanism protects him from easily being sort of cast aside or ousted.
So during the tenure of the former Chief Justice of India, D.Y. Chandrachud, resolutions of the collegium were published with reasons. The practice was done away with when Chief Justice of India Sanjeev Khanna took over and you were a part of the collegium. My pointed question is, sir, why is there this inconsistency in collegium decisions? And secondly, what was the thought behind it?
You see, every Chief Justice tries to work the system which, in his understanding, is the best way to function. Okay. For instance, you have talked about a certain practice earlier, before when the earlier Chief Justice was there, and now the current Chief Justice. For instance, Justice Sanjeev Khanna has started the process of recommended persons for judgeship being interviewed. In fact, you might also be aware that when the judges' retreat was there in Visakhapatnam, the recommended persons were interviewed by the collegium members.
Right.
So this practice was not there when the previous Chief Justice was there.
Right.
So it's always an evolving process. Now, when you give the reason, it had its own utility. But when you don't give the reason, that what utility it was being served. Because the reasons are he's meritorious, the reasons are he's being represented. I mean, that is otherwise also discernible. So that's how, I mean, there's not much, logic or analysis to be done.
But I think the point behind this is the principle of transparency.
Yes.
What the people at the bar or the people who read law really gauged from this entire act is that the collegium is being transparent when they're giving reasons. So do you think that that the principle of transparency was compromised in the next collegium decision?
You see, you are right in saying that part of the collegium exercise is opaque and not very transparent. But you can't also be forgetting that suppose you are choosing, let us say, for 4 vacant positions.
Right.
You are not concentrating only on 4. You might be concentrating on 10 people, let us say, right? So from a pool of 10, you shortlist 4. Now, why you have not shortlisted 6? There is a reason.
Right.
So if you have to take transparency to its appropriate level, you have to indicate why I have chosen 4, why I have not chosen 6.
Right.
Those 6 may be equally capable as lawyers, but they are not being considered for judgeship. But as soon as you disclose the reasons, their career will be affected. So it will be a serious prejudice to be caused. Then just imagine, nobody is going to say yes when the Chief Justice will ask, give your consent for judgeship. Because he says that if I am not considered and the reasons for not being considered favorably are disclosed, what will happen to my career? As it is, we are struggling, at least with good lawyers, to say yes to come to the bench.
Okay, I agree with you now. This is also a question which which I think you will be able to relate with. In the tenure of the last CJI and this CJI, and you were also a part of the Supreme Court when there were 6 Chief Justices of India's. But I think in the last stint, we saw most all constitution benches being headed by the Chief Justice of India. Firstly, I would like to know your view about this. Okay, and did you think that the practice of the CGI heading all the constitution benches is a correct practice, or there should be diversity where each judge, like in Justice Lalit's time, we saw even Justice Indira Banerjee was given a constitution bench at the last leg of her retirement, of demitting office. So do you think that practice was more, benefiting the judges who are there in the other benches so that they could head benches? What is your take on this?
You see, each Chief Justice will have a different take on it. And as you rightly said, Justice Lalit had constitution bench headed by different judges.
Absolutely.
Of course, you are also right in saying that Justice Chandrachud headed most of the constitution bench.
Yes.
But you cannot also forget, for instance, I have been part of several such constitution bench. And I also authored, he entrusted the responsibility of authoring judgment to me and also to my brother judges.
Of course.
So, and there were dissenting judgment also by us.
Of course.
Not agreeing with the Chief Justice and not agreeing with another opinion of another judge. So, that the Chief Justice is heading the bench is basically a decision, obviously, of the Chief Justice. He is the master of the roster. But by heading the bench, I don't think he's done any disfavor or disservice. Taking out these constitution bench matters which were in the back burner, I think Justice Lalit did a wonderful job by taking this out. Chief Justice Chandrachud again did that by carrying it forward and actually dealing with a lot of those cases and deciding matters. The reason is that Chief Justice is constantly struggling to balance the need of hearing the constitution bench matters, which will take up a fair amount of time, hearing time, and also to deal with the daily cases which are coming.
Right.
When the constitution bench, 7 judges, 5 judges are sitting, that many benches are not available to take up the regular cases. So therefore, there's a constant balance. So Chief Justice has to look for an opportune moment to, bring in the cases which deserves attention. And every Chief Justice has their.
And I think Justice Lalit's tenure was also too short for him to diversify the bench.
Despite that, he made a very serious effort.
Of course.
And he achieves some degree of success. But mind you, Justice Lalit is in a very unique position. He demitted office as Chief Justice of India. He was designated as a senior advocate of the Supreme Court. And he also worked as an advocate on record. This combination in one Chief Justice is not available with any other Chief Justice. So the closest observer of the Supreme Court, if you have to attribute to anybody, it would be Justice Lalit.
Well said.
Because as an advocate on record, he would be absolutely in the hub of things.
Yes. So there is a perception in the general public that the Supreme Court in the last decade has largely sided with the executive when it comes to contentious constitutional and political cases. Of course, there have been certain deviations like electoral bonds, etc. But how would you respond to this criticism? Do you think it's well placed?
You see, very often, now that so much media attention on any given case is there, as soon as a case argument commences, people are already decided what the outcome should be. In the understanding of that person, if he's a knowledgeable person, he feels that, okay, I know enough about law and this should be the conclusion. A layman would go by not so much logic, but he feels the judgment should be like this only. Eventually, the judge has to decide on the basis of what is being presented before them.
Right.
They have to balance the constitutional arguments that are being advanced.
Right.
What is the law on the subject, and then they reach a conclusion. I don't think criticism is fair to say that the court is siding with the executive in their decision-making process. If it was so, then say a particular judge or a particular court, it will always be in favor of the executive. It is not so. So in a given case, the perception of the judge, his understanding, his assessment of what is justice demanding in this particular case would largely determine what the final conclusion are.
Right.
Is what I think.
Justice Roy, a bench presided by you had granted bail to a cop, Mr. Pradeep Sharma, convicted for a fake encounter case.
Right.
At a time when there is a lot of clamor in the judiciary, or fact it's being debated that the higher judiciary has been sitting over cases of personal liberty for a very long time. Can you tell us what considerations go into the grant of relief to someone who has been convicted after a due process is followed, and what justified that particular decision in this instant case?
You see, to talk about a specific case and remembering the facts may not be this thing, but it was a serious
larger
case,
picture,
undoubtedly.
yeah.
But I think here it was not a unanimous verdict of the Sessions Court or the Special Court and the High Court.
Yeah.
The Sessions Court ordered for acquittal,
Yes.
and the High Court has converted them to conviction.
Right, sir.
Now, when there is a verdict of two courts, one had ordered for acquittal, other for conviction, normally, when the matter comes to Supreme Court, normally bail would be the norm, because he was on bail all throughout. There was no allegation. I'm not talking specific case. No allegation. We largely consider whether the person was on bail during the trial. We'll consider whether it is a concurrent verdict of the Sessions Court and also of the High Court. We'll also consider whether he has misused the liberty of bail. We'll also consider the seriousness of the case. So many factors are taken into account. And of course, the arguments that were presented must have appealed to our sense of justice, to say that a man who has been on bail all throughout or largely should this thing. But I think there, if I remember correctly, instead of saying bail certainly, we said perhaps he need to surrender and then be given bail. Just to sort of put the thing that, look, the man has to surrender and then he should get bail. I think, if I remember correctly.
But you're saying that these are the broad parameters on which...
parameters, it can be...
I am very tempted to ask now, this is off the cuff question, but when you get these cases in the evening, your clerks get you these are the cases. Do you have a formula in mind which you know of that, you told me the factors. So when you read a case, do you quickly look for these factors so that you know what could be the probable decision, or you wait for the arguments to be made?
You see, things like bail, etc., those are, I think, mostly very simple issues that a judge has to deal with.
Right.
So the parameters which I have indicated are broadly are those. Then the parameters will differ in regular bail and anticipatory bail.
Right.
They will be different.
Right.
So, but it is never a situation of we having made up our mind in the chamber in the evening before. Okay. It is always we reach our conclusion, even if we may have a thing. But you must also understand that if we have, let us say, 60 or 70 briefs to read the previous evening, how thoroughly you might be able to read a particular brief. So you are just getting, let us say, a flavor of the case.
Yeah.
Not even page-wise, So you're just getting a flavor of the case. And then...
it's built upon by...
Yeah. The advantage of a judge is that he can ask questions of the lawyers, and the lawyer is bound to answer. So the judge has the flavor of the case. Then he will ask the lawyer, okay, there is too much of a saline element. Where is the sweetness? So the lawyer will say, here is the sweetness. Then you balance the salinity and the sweetness, and then thereafter you give your verdict.
Right. So there were reports, including from us, about the recent round of senior designations in the Delhi High Court, Supreme Court, etc. And there was a lot of acrimony in some sections regarding those level of senior designations. There was also certain reports about acrimony among the full court members while those designations were being made. My pointed question is there any truth to it, or was it a unanimous decision to designate this?
The acrimony was certainly not there. That is rumor mongering.
Okay.
I think the decisions of the full court was cordial. I mean, meaning thereby it is not a blind decision, meaning thereby there were discussions. Why A is being recommended? Does he have or does she have the credentials? All right, there will be an answer back and forth. There would also be a situation of why so-and-so is being ignored. Okay. Right, these are the reasons. If somebody was in the contention, that is.
Okay.
So, acrimony certainly was not there.
Okay.
But free and fair discussion, you can certainly say, was there.
So what is your take on the delays that are being caused by the executive on clearing appointments and transfers that are recommended by the collegium? Is there any end to this back and forth ever?
You see, this is a problem which I think every every Chief Justice or particularly the Chief Justice is confronted with. And whenever there are opportunities for the Chief Justice to interact with the executive at a particular level, I'm sure these are discussed. So for instance, say my parent High Court is Guwahati High Court. There are two recommendations, one of a lawyer, practitioner from Guwahati High Court. The other is of a lady judicial officer. She is a tribal Naga lady. These two are not being cleared for considerable amount of time. So as a judge, as a judge from Guwahati High Court, obviously once in a while I get queries what is happening. So I've had occasion to also speak with the Chief Justice. I, as a judge, don't have a direct access to the executive.
Your law ministry.
So I've said, and Chief Justice definitely have indicated that they are trying to follow it up. So the point that you are trying to make is that sometimes they sit on the recommendations. We are seeing that and hope, of course, the Chief Justice also, earlier Chief Justice, the current Chief Justice also said, yes, we are working on it. We are working on it. But you can't put a sledgehammer and...
So that's what I wanted to ask. Is mandamus is not a way out in this scenario?
You see, that is the ultimate weapon that the judiciary might wield. But if you recollect the time when Justice Sanjay Kaul was there, he was monitoring he was heading a bench which was monitoring the process of appointment, right? So there's a bit of a back and forth. Say Attorney General will be appearing or some law officer will be appearing, and then the court would say, all right, we have recommended these 20. Out of that, 12 are cleared, 8 are pending. So let's say the law officer will obtain instruction and come back. We are in the process of clearing 6. 2 will require further inquiry. So there's a bit of a dialogue going on.
Right.
And that dialogue is not in the back room.
Right.
It is in open court. So this particular process of dialogue,
right,
it gives confidence to the observers of the court process.
Correct.
Right. That there is a bit of an effort being made by the court and there is a bit of a reaction by the government. And through that process, names are getting cleared. And if some names are still being held, you can still ask in the next round. So that could be. But to say that I issue a mandamus to appoint or issue the warrant of appointment, that is the ultimate thing. I would think that last resort
is not needed as yet.
That's a last resort, you see.
Okay.
Sometimes there could be very good reason by the government for not recommending or not this thing. Of course, I am not privy to specific cases.
So I still remember a very interesting instance when you were sitting with Chief Justice of India, D.Y. Chandrachud, as he then was, and you had said that the Chief Justice says that if you read digital files, then you become younger. So, just taking a leaf from that, some Supreme Court judges are known to be very tech savvy.
Yes.
Right? And some are not so much.
Yes.
So, some allow hybrid hearings and some days of the week and some not. What is your take and why? Do you think this mode of hybrid hearing is the way to go? Or do you think that physical appearance of lawyers is actually needed for courtroom arguments?
You see, there are two ways of looking at it. I feel that for young lawyers, for women lawyers, the opportunity to appear in the virtual mode has leveled the playing field to a large extent.
Okay.
So this needs to be sustained. After all, women are equally capable of performing as well as men, because it's an intellectual exercise.
Of course.
In law. I mean, there's no physical element involved. So therefore, the only thing that sort of stops them from performing as well as men are sometimes which relate to the distance, the commute, etc.
Okay.
Right. So I feel that this is a very important thing, which maybe COVID had expedited the process. So this is necessary and it must be continued. But very serious constitutional cases, if the lawyers are arguing from distance, I think the effect is a little less. And I would suggest that in complex, complicated cases where multiple questions are involved, multiple legislations are involved, for a lawyer to argue from, from another place, not being present physically in court, I think that is not a very good idea. Their physical presence in court and argument in court
makes a difference.
Makes a difference. It's much more effective, and they are able to communicate better.
Right. So will you be, this is a very standard question we ask, but will you be accepting post-retirement opportunities?
An offer to me was made by the previous Chief Justice. To me. No, not specific offer.
Okay.
Hrishikesh, would you be interested on some official listing? So I politely declined.
Okay.
In recent days, from the government side, somebody reached out to me making a specific offer. I also declined. Then the officer of the ministry was sent 4 or 5 days later to again reiterating the request. Again, I declined. My take is that I don't want to accept any government official assignment of the kind that was being offered. I mean, these are all prestigious posts, undoubtedly prestigious position, but I would like to be a private, ordinary individual after having worked as a judge for about 19 years now.
In arbitration?
Yeah, possibly that's an option because, as you know, Delhi is a very expensive place to live in. And the pension that you would get as a judge would not enable you to rent a house.
Plus, you're very good in arbitration. So
no, not necessarily so, but then perhaps some opinion work. So perhaps those things.
So nothing of...
no, not
you won't be disclosing what was it? What was the offer about?
It may not be proper for me.
Right.
You can visualize what are the positions
we
available
won't,
at the time when Chief Justice Chandrachud made the offer.
Yeah.
And
I think one of them has been filled now recently, I feel so.
Let us not talk. But I must say, he did not mention any specific position. He just said that, would you like
if you're interested, of course.
Interested. He didn't mention any position.
So, what is the way out to address the low representation of women on the bench? It is extremely low. The figures are dismal, so as to say.
You see, I was Chief Justice in Kerala. We had, I think, 9 lady judges. Delhi High Court also, they have several. Guwahati also, at given point of time, we had fair number. The only way is for the women lawyers to mark their presence, particularly in courts where matters are dealt with by the Chief Justice. There's a bit of a disadvantage. Very often you will find that it's not universally true that women lawyers are being engaged in family law related matters. Therefore, family law related cases don't come to court number 1. I'm talking about the High Court. So where is the opportunity for them to get exposed to the Chief Justice's court or the Senior Judge's court? So they must accept and move out of the comfort zone, accept matters which are also to be argued before the Chief Justice's court. Just to tell you, when I was Chief Justice Kerala, first time the entire responsibility of how to make the recommendation was an issue before me. So I wrote a letter to each of my colleague judges, women judge, male judge, each of them, saying that we have so many vacancies. We wish to make recommendations. Can you give me, keeping in mind this many vacancies, names of 20 or 3 times or 2 times the numbers, in your perception, who should come as a judge?
Right.
That information came to me confidentially by each individual judge. Those informations are collated. You will find when you are bringing a list from, let us say, 30 judges, at least 5 names would be common in all the list. So that means each of the judges in the High Court thinks that these 5 should definitely get a call for consideration for judgeship.
Right.
Then there will be let us say out of, let us say 30, so 25 would have zeroed in on another 4, 30 would have zeroed in on 5, 25 would have zeroed in on another 4. So then you shortlist, though the people who have been recommended the maximum by the maximum number of judges, they are obviously in your priority consideration. Now their cases may not be getting listed in the Chief Justice Court. I may not be familiar with most of the persons shortlisted. I gathered information from the court registry only, and then arranged for listing of these cases of these lawyers in my court. Suddenly people are thinking, why the Chief Justice Court normally deals with these roster? How come these matters are also suddenly appearing in the Chief Justice's Court? So I was hearing these lawyers who were recommended by my colleagues. And then after I found how they are doing in the court cases that they are appearing in my court, we shortlisted, then I arranged to have their cases listed in my court. And eventually it was a decision, although you may have recommended a particular name, but I didn't go by just your recommendation, but I personally satisfied myself on their capabilities and then made the recommendation.
Right.
So this, my colleagues in Kerala High Court, they appreciated it a lot. So I feel a little good about making those recommendations. And when I left the Kerala High Court, I filled up all the vacancies, either the seats were filled or the recommendation for the remaining vacancies were in the pipeline.
So just, we are coming to the fag end of the interview. You had once said that arbitration in India is like an overloaded truck saddling up the hill. Are the courts and the government of India also doing enough to make the country a potential hub for international arbitration?
You see, when I said arbitration in India is like a truck struggling up a hill, I spoke about in the context of whether the arbitration world is as vibrant as people expect it to be.
Right.
And the obvious feeling is no. And there are several reasons, but you see, one reason you as a person coming from the bar and bench would be a very keen observer. And you will know that the government gives signal that we want to make India as the arbitration hub.
Right.
We want to compete with London, we want to compete with Singapore, we want to compete with Paris. So that's how you this thing. And at the same time, you are also issuing notifications that public sector undertaking of value of so much, work value of so much, will not opt for arbitration. So the signals are not uniform signals that are going across from the government side. You are trying to attract investment. Now, anybody who is putting in money, he would also hope for, in the event of a dispute happening, for an early resolution of the dispute in an acceptable fashion. And arbitration universally has become an acceptable mode of dispute resolution in a quick and efficient manner by engaging experts and not being dependent upon the court process, which is there. If you have a system in place where you can deliver results in a more efficient and in a more effective way, certainly the arbitration should be the answer. And why should the court docket? You talked about liberty a little while back.
Right.
Arbitrations are hardcore commercial matters.
Right.
Why should a litigant crying for liberty, languishing in jail, why his case should not get priority in the court system? Because only the court can order for acquittal, court can only order for reduction of sentence, not the arbitrator. So therefore, liberty-oriented cases should get priority in courts, whereas the commercial matters, they should be dealt with in a commercial fashion through arbitration, through people who are good with the process and who are also effective. So I do believe that arbitration should be opted as a effective means for resolution of particularly commercial disputes.
Right. Justice Roy, you are known to don many hats. of which being a theatre and a film enthusiast is one which you include in judgments too. Um, Given the taxing work schedule which you had over these years, whether it be at the High Court bench or at the Supreme Court, um, were you able to catch up with any recent movies and songs? And we see you direct any theatre anytime soon?
Movies, I don't see so much, but theatre I do.
Right.
So theatre I do, and right now, currently, I have in my pocket the list of the plays which are on display in the National Theatre Festival being organized by the National School of Drama. This
Okay.
is on in February. So maybe earlier times I could not see as many as I wanted,
Now you will.
but now possibly I'll be able to. But more important than theatre, I am also a lover of books.
Okay.
At any given point of time, even if it is only for half an hour a day, I'll read some pages of the book that I'm currently reading. And it is usually two books going on simultaneously, because at a given point I may not like to read book A and might read book B.
Right.
But I have a peculiar practice, because I do, besides every day before going to bed reading some pages of a book, I also read while traveling by air. But I don't like people peeking at which book I'm reading. I usually put a white cover on my book
Oh,
when
is it?
I'm traveling by flight and I read the book.
Okay, so you
Somehow
don't-
I feel a little uncomfortable when
Privacy intrusion, is it?
No, not so much privacy. Suppose say people know that, or people get to know I'm a judge.
They form
And
an
suppose-
opinion.
Yeah, I mean, and then say that all right, he will be reading some law book. I might be reading a book on sports, or I
Right.
might be reading a book on some entertainment or
Right.
some theater.
Right.
I said, why my interest, the kind of books that I read, why should it be known for everybody?
Okay.
If a friend asks for an opinion, I'll certainly make recommendations, but not a book. So in that context, in one of the recent judgments, when the things ended, so Chief Justice Chandrachud said that leave the last word to Justice Roy. Then I said, we cook judgments, because that time I was reading a book, the title of which was Cooking Books.
Okay.
The title of the book is Cooking Books. Was it Ramchandra Guha or one of these, this thing, the author? You can just check up Cooking Books. So I said, last book that I was reading is Cooking Books. As judges, we cook judgments.
Yeah.
We put a bit of meetha, we put a bit of khatta, we put a bit of tikha, and try to balance. And that particular judgment was, I disagreed with opinion expressed by Chief Justice Chandrachud.
Okay.
I also somewhat disagreed with the view of Justice Narasimha. We are same combination, but there were two views. So I wrote out my third view, saying that I'm trying to balance the tikha and meetha of these two judges in my judgment. So that is cooking book and cooking judgments. So book reading is one of my hobby.
So theatre is something that is topping your list.
Theatre is also in my hobby. So
And it's Guwahati Music Academy.
Music Society.
Music
It
Society.
got disbanded, because you see what happens, any organization is usually moved by one or
People.
two persons, right?
Yeah.
So when I became a judge, the others found losing the momentum.
Right.
They did one or two shows after that, but they said that it's not the same thing without you. I'm very grateful for their saying it, but perhaps, sometimes people gel.
Hope to rekindle it again.
Hopefully. But people have become older now.
No, not at all, sir. It was a pleasure having you, sir, with us.
I really
it was great
enjoyed
speaking.
this conversation, and I don't know how you people manage to do the work that you do. I must compliment
No, thank you so
Debayan,
much, sir.
for this good work.
Thank you, sir. Thank you so much, sir.
Thank
Thank you so much.
Thank you.